I'm so excited to be joined by Professor Eric Helland and a number of special guests to lead us in a talk today on LA court cases, which is fantastic. Just to tell you a quick background of Professor Eric Helland, he's the William Podlick Professor of Economics and George R. Roberts Fellow at CMC and an adjunct economist for the Rand Corporation. Professor Helland has authored over 50 books and articles on topics from law and economics. I read that apparently, Professor Helland, you have also talked about bounty hunters and judicial elections, which is pretty exciting. His current research focuses on pharmaceutical and patent litigation, securities litigation, auto safety, and medical malpractice. He's also an expert in civil law, crime, and the intersection of economics and government. On campus, he co-chairs the Policy Lab, which I'm hoping he'll talk a little bit about today. He's a beloved professor in the classroom, and fun fact, Professor Helland taught my Econ 50 class when I was a freshman in the fall of 2016. So this feels like a great full circle moment. Professor Helland, I'm very excited to turn it over to you.
Thank you so much. Let me begin by saying thank you, everyone, for coming. I do want to actually just take the first part of this and talk about the Policy Lab. I'm going to share my screen. So let me know if this goes horribly awry. This is a project with the LA courts and the Rand Corporation, and I'll sort of explain how this works. And then I want to actually bring Judge Kuhl and Judge Heiberger on, who are not only judges in the LA Superior Court, but also parents of a CMC alum. This is kind of fitting with the general theme of the alumni talk. So a little bit about the CMC Policy Lab. What Professor Zach Corser and I sort of put together probably about 6 or 7 years ago now was an attempt to kind of build on one of the real strengths of CMC, which is the ability for students to engage in research as undergrads. And if you know anything about MPP programs, there are a number of policy labs around the country, but they're usually in master's in public policy programs or in law schools. And what Zach and I really wanted to do was give a chance for students to take a class and get a chance to sort of have some research experience working with a client. So for example, at the Harris School at the University of Chicago, this is called City Labs, and the master's students will be sort of paired with a client who needs some analysis done. And we thought we could do this at CMC. And so we've done a number of projects. We also work with students in terms of internships, and also we're the capstone course for the Master's of Public Policy. And there are actually a couple of alums of the program on this call as well. Shout out to those of you that have come through the Policy Lab. What in this particular instance, what we did was that we worked with the Rand Institute for Civil Justice, where, as Josh mentioned, I'm an adjunct economist, on looking at debt collection cases in the LA courts. And in particular, we enlisted 2 judges of the LA courts, Judge Kuhl and Judge Heiberger, who have a long connection both with Rand and with CMC. And we asked them to sort of be our clients, if you will, to sort of work with the students. And just to give you a sense of how generous these 2 are, they actually came out to campus from downtown LA, which is not a trivial undertaking, I will tell you, came and spent an afternoon in the Policy Lab, which, to be clear, is actually a trailer located on Center Court that has seen better days, but they packed in with 25 students and basically gave them a crash course in court procedure, debt collection law, and really sort of brought them up to speed very, very quickly. Before I turn it over to Judge Kuhl and Judge Heiberger to talk a little bit about what some of the issues and why they wanted to work with the Policy Lab, I want to just point out one thing, that for a lot of our students, this is the first time that someone has given them a question where that person didn't know the answer. And let me explain what I mean. When you get a calculus problem in high school, I promise the teacher has worked it out. When I give Josh an Econ 50 problem, I know what the answer is before I sort of give it to him, right? And I think one of the things that's very disconcerting for students, but hugely sort of helpful in kind of understanding what their lives are going to look like after graduation, was having two judges from the LA Superior Court come in and say, here are some of the issues we are facing, and we don't know the answers or how you're going to sort of solve this, but this is what we're sort of really interested in. And I'm telling you, when you left, Judge Heiberger, there was sort of a kind of giddy silence in the room where the students just realized how big a sort of undertaking this was. And I'm really proud that after doing this in the class and then in the summer, we have results. I'll show you those results. But before I do, I just wanted to give Judge Kuhl and Judge Heiberger a chance to kind of talk about this, because it's really nice to actually get our clients here to talk about it. So over to you both, and thank you.
Well, this was, I'm Carolyn. This was a wonderful opportunity for Bill and me to interact again with Eric. He's done such terrific work looking at issues that really matter to our court. And before I go any further, I just want to give a shout out to Judge Mark Wyndham I saw on the call. Hey, Mark. Another Los Angeles Superior Court judge. So the Superior Court takes care of all the problems that people have to come to court for that can't be solved anyplace else. We're not like federal court and can only do, felonies and top of the line work. We have to take care of people. And so we do have questions about how legislation affects our work, whether reform legislation, in this case, in the debt collection arena, really made a difference. And are we doing a good job? Are we handling the cases in a way that's fair? Particularly important in debt collection cases, because we know most of the debtors are not represented and most of the creditors are represented. So in this instance, with Eric looking at the court data, he tells us things. He's able to tell us things about how we're doing, and then what he learns from the analysis hopefully also can contribute to a larger and more national dialogue and public discourse that's going on about debt collection and debt burden and its socioeconomic impacts. I really can't say enough about these students that we met. It was that afternoon. It was such a pleasure. They were so enthusiastic. They were at the outset of the project already so devoted to the project. They were smart. They were eager to learn. And just so you know, they were sitting through discussions about the distinction between defaulting on a debt, entry of default when someone is served with a complaint and fails to answer, and a default judgment. Those are all three different things. It took really a little while for me to explain them to Eric, but the students were just really getting into this. And there they were in the trailer. They were so happy. And this really is a CMC program that deserves support. And I was glad that Bill and I could help a little bit. So Bill, how did it feel to be a client?
Bill, you're on mute.
Greetings. So the students were so enthusiastic. It was a delight to be with them in the trailer. And I remember back to my college days doing some survey work and research work, having the kids get their fingernails dirty, figuratively speaking, dealing with real data. And as I'm sure Eric will explain, it's not the easiest data to access. Eric is a pioneer in trying to deal with court records data, and the courts don't cooperate. And that's even true of our own LA Superior Court. So Eric and his team had to go get the data by scraping it off of our public website. We helped them try to understand what they're going to get when they scraped it. But it is real, practical, concrete research work by his students, learning how to deal with messy data and getting it organized enough that you can start drawing some statistically valid conclusions by summarizing it. So it's always a delight to work with Eric. And my fun fact is Eric and I are both preacher's kids.
Yes, we are, which may actually tell us a lot about both of us, but we'll save that for question and answer.
Back to you, Professor.
Thank you both. And I really cannot say how grateful I am to both of you for sort of coming out and doing this. It meant a ton to the students, and really this wouldn't have been possible without you. And in fact, I should also say was suggested by you. as something that we should sort of look at as a place that would have some potential reforms. So let me sort of get right into kind of what we did. Look a little bit about debt collection cases in Los Angeles and generally. So these are the most common case now on the LA civil docket. And just to give you a sense, historically, that would have been, back 30 years ago when I started sort of looking at researches there, that would have been an auto accident. It's now a debt collection case. I'll explain more in a moment, but LA, in a lot of jurisdictions, these cases are really clogging the civil dockets. And so in Texas and Florida, these cases are just sort of assigned to sort of all judges on the civil docket. LA has done something really different. They've created two courts that are collection courts in Norwalk and Chatsworth. There's about 80,000 cases a year handled by 4 judges. And so one concern might be that that would affect sort of what's happening to defendants in these cases. I'm going to give you some evidence that suggests that hasn't really had a deleterious effect. And if anything, it may have caused a sort of a greater rate of scrutiny of some of these filings. Collection cases are really different from other cases. There's a very small number of plaintiffs. I'll show you some evidence on this. Many of those plaintiffs purchased the debt from the original issuer, which means if you were to get a notice that you were being sued by a collection company, it would not necessarily be from the company that you had incurred the credit card debt with. And I think that's a sort of important fact here. As Judge Kuhl mentioned, defendants typically do not respond to the summons, which means that many of these are defaults. Only about 3% of these defendants are represented by an attorney. Why should you care? And the answer is, one, we really should be concerned a little bit about these being one-sided. And here's what I mean by that. The courts are the neutral arbiter of disputes in our society. They're the place we go to have disputes between two people adjudicated, and they're set up in a way to sort of have people who are represented by attorneys. That's not a criticism of the courts. I'm not sure how else you could sort of set things up. But you do start to run into issues for the court when only one side is represented, let alone appears. And so I think the first thing we should be worried about is, that these are pretty one-sided. As I said, in other places, we're worried about these debt collection cases clogging up the system. That's less true in LA. The third is a lot of the reforms that are being proposed involve additional filings, sort of additional scrutiny, but a lot of them are reforms that really require the person to respond to the summons and in many cases have a lawyer. And being an economist, I'm going to phrase that as we may have reached diminishing returns on those type of reforms. The type of reforms that I think may have a bigger impact are ones that involve greater legal assistance. The problem is that, as I'll show you, these cases are fairly small and they're not going to pass the cost benefit of hiring an attorney. They're going to be very valuable to the person, but attorneys are expensive. And then the last is, and so I've got some things to say about that at the end, these collection cases may have secondary effects on low-income people. And I'm starting to do some research on this now, but remembering that the outcome of a lot of these default judgments is going to be a garnishment of wages or seizing assets in a bank account. And so that might lead us to be concerned that this is increasing homelessness, causing people to work in an informal labor market where their wages can't be garnished because they're being paid under the table, failure to pay child support, and so on. So I think one thing we might be concerned about is these secondary effects, but then to carry it back, almost all of the ways in which we could deal with those secondary effects require that people basically appear in court. They respond to the summons in some way. Otherwise, there is very little the court can do. So that's my quick pitch for why you should sort of care about these. Judge Heiberger mentioned how we sort of did this. We actually scraped the LA court's case management system. We have 500,000 cases. That actually gives us a lot of information. And I'll skip over this list for want of time, but just to give you an idea, this is what the docket looks like on the LA court's publicly available system. And from this, we're able to figure out, was the person represented by an attorney? Did they sort of appear in court? And we know a lot about sort of events that occurred. There's some things we don't know because they're in the filings, but not on the docket. So think about this as Judge Heiberger has a case before him, and as various actions transpire in that case, entries are created in this electronic system. When the case is resolved, that is archived, and we're able to sort of scrape that and get that information. We also have the ability to get the filings. Those are publicly available as well, and they contain additional information. This was actually most of what we did in the first semester on this project, which was the students put together a coding protocol and hand coded a lot of information about these cases that's not available in the docket. The most important one on that is actually the defendant's address, which is in the summons. Why is that important? It allows us to gain a lot of information about who these defendants are, and I'll show you some on that in a minute. So initially, what Judge Heiberger gave us comments on was a coding protocol. And again, with my hat tip to both of the judges, they gave us very, very detailed comments, which was we got a lot of it wrong. And we went back and sort of corrected that and did a second sort of round of work on the set of data collection. So when Judge Heiberger says it's really important to have someone explain to us what's going on, it really was. These are very idiosyncratic terms, and it was very, very helpful to have people telling us what do these things mean. We ended up with 500 cases just randomly selected from the scrape data that we collected information on. But as I'll show you in a minute, very few of those people had attorneys. And if we're interested in the effect of representation, only about 3% of the defendants have an attorney, which means we collected a second sample of 500 where we only looked at defendants who had an attorney. So we have 2 hand-coded samples just to see sort of where people were. And then for reasons that were Judge Heiberger explaining sewer service to the students, quite independently, the students decided they wanted to collect another 800 cases this summer of cases where there was secondary service. And I'll explain what that means in a minute, but suffice it to say, this is where I go to Josh's house to give him service on his debt collection case. Sorry, Josh, you're the victim du jour here. And Josh isn't there, or at least I don't know if it's Josh, but because I know it's Josh's address, I give it to someone who says, that they will that they will take it, and I can do a second sort of a substitute service. And one of the problems with this is if the courts wanted to audit this, we need to know who that person that received that was. And I'll show you some evidence on that. About a quarter of those cases are delivered to someone who is listed as anonymous. And the Judge Heiberger's concern with sewer service is when the process server says that they served the person but didn't. And that might explain the very high rate of people sort of not appearing in court. And so the students sort of dug into that. The thing that we were able to do with this, and I'll show you this evidence in just a second, was that when we know the person's name and their address, we can geocode that and use a statistical method used by the Consumer Financial Protection Division to essentially predict someone's race. It turns out your last name is pretty indicative of your race, as is the zip code or census tract or census block that you live in. So what we were able to do was take that information, use the Consumer Financial Protection Bureau's system, and we were able to update it. And so just to give you an idea, it turns out Eric Helland is a very, very Norwegian name. And you can predict with a very high accuracy that I'm white. Put me in Claremont, California, and I think I ran this through the system. It is 99.3% likely that I'm white. That's very useful for us because it allows us, the LA courts do not and could not collect data on people's race, particularly with the very high rate of default, but we're able to sort of get a sense of the sort of race, income, and in particular language issues that people might be facing. So I'll show you some evidence on that. So what are our key findings, just in case I run out of time, because Josh has told me I've got a hard out at 40 after. So basically what we find, unsurprisingly, is that these cases are filed in zip codes with high minority populations, particularly Black and Hispanic communities. They're disproportionately low income, and they're disproportionately zip codes with a high limited English proficiency. We don't find statistically significant differences in outcomes in these cases in court, but we do find differences in sort of filing rates. As Judge Kuhl said, the typical case, actually not just the typical case, the vast majority ends up in a default judgment. That is, the person does not respond to the summons. Collection cases increase the amount owed by defendants typically because these are default judgments. Court fees and other things are simply added to the defendant's amount that they owe. That amounts to about 13% extra. And as other studies have found, the vast majority of these cases are filed. The plaintiffs are a small number of firms. One thing I want to point out is, look, and this is something Judge Kuhl said to the students in their talk there, and it was a bit of a surprise to them, which is, look, it's really important to have a collection system or people don't get credit, and particularly low-income people. And so one of the balancing acts here that we talked a lot about in class is how do you have a system that is both fair and lets people know that they're being sued, but also provides a mechanism by which people, that are issuing, or firms that are issuing credit can kind of collect that in event of a default. And so I just throw that out there that we sort of had a lot of policy discussions sort of around that. One thing about this is, as I said, a lot of these are bills are sold on the secondary market. Federal Trade Commission finds they're worth about $1,600 as the balance sold. Obviously, it's a higher balance if someone's willing to sort of go to court. The debt buyers typically pay about 4 cents on the dollar for these, which gives you an idea of how hard these are to collect. I'm just going to go over this very, very quickly just to show you the results, but suffice to say, California probably has some of the most pro-defendant, pro-debtor laws in the country. California mirrors all of the laws, obviously at the federal level, but California has the Fair Debt Buying Practices Act, which requires a higher level of proof that the debt is owed than other courts. It has limited the statute of limitations sort of further. And so I would say California's probably gone farther than just about any other state in the nation in terms of putting safeguards in place to try to make this sort of system fairer for defendants. As I mentioned, California or Los Angeles courts, by the way, is the largest court system in the country. It's larger than the federal system. It handles more cases. It is simply a massive court system in sort of a very large county. And what happened in 2012 was the LA courts consolidated debt collection cases into 2 courts. I'm not going to show you a lot of evidence on this today, but one of the things to note is the outcomes look very similar or are even a little better for the LA courts in terms of how these cases are adjudicated. There's a higher dismissal rate, for example, in the LA courts than there are in some of the other courts we've looked at, which suggests that this consolidation didn't seem to have a deleterious effect that some people were worried about kind of early on. Most of what the court does is uses a checklist to go through the filings in collection cases to make sure that they're complete and accurate. At least judging from the dockets, most of the issues have to do with service and problems with service. And much of the work is done by clerks. And in a very high proportion, the defendant doesn't respond. So there's the clerks are kind of the last sort of step in kind of checking these filings. This is a daily plot of filings in the LA of collection case filings by in the 2 courts, Chatsworth and Norwalk. What I've done with the red lines is put on the various reforms. And the takeaway I want you to get from this is there's a real ebb and flow in the timing of these filings. But if anything, there's a very slight upward trend. And my point behind this, when I say I think we may have reached diminishing returns, is a lot of these reforms have kind of raised the bar on what needs to be filed in these cases, but doesn't seem to have dramatically deterred sort of filings. Again, hard to say what they would have been without these reforms, but I simply mention this because I think in some sense, a lot of the findings we're going to show are going to deal with access to justice issues rather than attempts by state law to screen out cases that are problematic for some reason. So who are the plaintiffs? Well, the first thing is about 75% of the plaintiffs the cases are filed by the same 10 firms. And so one thing to note is this is a very concentrated set of cases being filed by a very small number of large firms. Some of those, this is the most frequent, the list of sort of who's on there. The thing that you'll notice about this is some of these are credit cards you have in your wallet, and some of these are companies you've never heard of. And I do think that's important because if you were to get a notice from Portfolio Recovery Associates, by far the largest percentage of cases filed, it's a secondhand debt buyer, you might not know who that is. And I do think that's kind of an important factor here, is that you might have accrued debt from a target credit card that you're delinquent on, and that delinquent debt has been sold to a secondhand debt buyer, and you may not sort of realize who that is. So I do think one important feature of this is that these are often not the firm that sort of issued the debt. Who are the defendants? Well, this map basically is a heat map of the percentage of non-Hispanic whites. So darker colors are a zip code with a higher percentage of non-Hispanic whites. Lighter color is a lower percentage of non-Hispanic whites. The two courthouses you see are Chatsworth and Norwalk on there, just so you get a sense of where the cases are, or the courthouses are. And what you notice on this is that these cases, these are our 500 randomly selected cases. They are disproportionately filed in areas with higher percentage minorities. Here's the relationship for income. Darker blue is higher income, again, disproportionately filed in sort of lower income areas of Los Angeles. And then this is the percentage of limited English proficiency. Again, darker colors are lower numbers of limited English proficiency. Lighter colors are higher. And so again, higher percentages of limited income proficiency, higher proportion of debt collection cases per capita in the zip code. And so I think what this tells us is the defendants are disproportionately lower income, non-white, and with limited English proficiency. So that's the first takeaway. And I will say this is one of those findings that's not in the literature, at least in this way, and is really due entirely to the policy lab students being able to sort of collect this data. It's very costly to sort of do, and it would be very hard to sort of automate. What percentage of the defendants have a lawyer? The answer is not many. It varies anywhere between about 2% and as high as about 5%. The average over the years is about 3%. It's a very low sort of percentage. What are the outcomes of these cases? Well, the first thing that Judge Kuhl mentioned is very few defendants respond at all. The average there is 92% do not respond. That is, there's no answer, denial, no other response found in the docket, which means these are defaults. The second thing is about 45% of these cases are dismissed. Now, I should be clear what a dismissal means in this case. It could mean any number of things. Again, Josh, you're my defendant du jour. One possibility is Josh does not respond to the summons to the court, but he picks up the phone and calls the plaintiff, and they work out a deal, and the plaintiff simply drops the case. So this could be a settlement. I'll show you some evidence that that's probably not the sort of majority of these in a minute. But more than that, what a lot of these are is that the court has found a problem with the filing, and the plaintiff has chosen to sort of withdraw it, or after a certain period of time, the court has simply dismissed it. Those cases can often be refiled in the vast majority of cases. But I think one thing this tells us is that the courts are screening. They're going through these and they're sort of finding problems, again, mostly with service. And so I want to sort of raise this as a my hat tip to the LA courts. This is not a general finding when people sort of look at other courts. Often the dismissal rate when the person defaults is much lower than this. So one shout out to the LA courts. The proportion with default judgments is about sort of, well, bluntly, it's all the cases that don't get dismissed because it's 92% of the people sort of don't respond. So it's a very high rate of default judgment. A lot of these are by clerks, and they result essentially from something called the consent to judgment, which says earlier the collection company contacts Josh, he works out a payment plan, and then he defaults again. But in the interim, he has signed something that says if he defaults a second time, it automatically becomes a default judgment. It's a sort of admission that he owes the money. And so most of those are handled by clerks. But even so, judges are reviewing these, and there's a fairly high percentage of default judgments by the court. The LA courts does have a notice for settlement. This would mostly be when the person does respond. The courts can know that the person has worked out an agreement. You'll notice those numbers are pretty low. It's sort of anywhere from sort of 3 to 5% of the cases where there's an agreement worked out, where Josh says, I will pay you, $800 on the, $1,800 that I owe, and we'll call it even. And portfolio associates would say, great, we sort of accept that, case is resolved, and they sort of let the court know that that is not the typical outcome. A lot of these cases that have a judgment have a writ of execution. That essentially is an order by the court that allows the plaintiff to garnish Josh's wages or seize money from his bank account. There are some limits under California law on how much they can do that. To be quite honest, it's very hard for the courts to know if those rules are followed. These are actually executed by the sheriff's department, as I understand it, but they need this writ. We think this is kind of important because really this would be the writ that you get when you don't have a resolution with the defendant. The case is not settled. So this suggests a lot of these defaults judgments are simply resulting in wage garnishments or seizing of assets in the bank account. So what about when people have representation? Now, I want to just be real careful and explain what this diagram means, because then I'm going to show you a bunch of them really, really quickly, because I have like 7 minutes left. And basically, the vast majority of these cases are default. So think the 92% are in the left-hand side of this. The about 8% are pro se, and then, about 5% are pro se, and about 3% have an attorney. And the way to read this is the case is much more likely to be dismissed if you have an attorney. It's also much more likely to be dismissed if you respond. So the dismissal rate is about 45%. It jumps to sort of 55% if you respond, and it jumps to 75% if you get an attorney. So the first is representation matters. One interpretation of that is when we go through the filings, that really looks like this has to do with statute of limitations on debt. California's been very aggressive on not allowing debt past a certain age to be collected in court. But that's not something that it's easy for the courts to monitor. And so it really helps to have an attorney that says, hey, that debt you're trying to collect from Josh is actually outside the statute of limitations. And so we think that's really where sort of attorneys are kind of driving this. Attorneys actually are slightly less likely to settle. We think that's because most of the time they get a dismissal. But pro se plaintiffs seem to negotiate an agreement with the plaintiff at a much higher rate. Obviously, with default, we don't know anything about it because if it's a default, the court has no one to ask if there was a settlement. And then in writs of execution, far less likely in cases with an attorney and less likely with pro se. Again, we take that as when the person is there, the courts sort of work out, the individuals work out an agreement with the plaintiff to sort of resolve the outstanding debt without wage garnishment or seizing a bank account. Outcomes by race. The big takeaway here is it's not going to differ very much by race. So remember, big differences in who's coming into these cases, not huge differences in how the court is resolving them by race. So again, default judgments, no sort of big differences across race, a little bit of a difference between Asians and Hispanics. But beyond that, we don't find much in the way of differences. Just to describe those for those of you that are want to go back to your statistics days, those are confidence intervals put in there. For those of you that find confidence intervals terrifying, ignore that and just look at the levels. It's sort of not particularly important. Not much difference in by race in cases being dismissed. Not much difference in settlement. We do, interestingly enough, find that Asians are slightly more likely to have attorneys than sort of other races. No explanation for that, but that is one that sort of stood out. And no differences in writ of execution. So the courts are getting a very different mix of sort of people, and our interpretation is within those, the outcomes are pretty similar. I just wanted to mention service, and then I'll talk just for a second about in my 3 minutes remaining. Remember, service is the process of notifying you that you're being sued. It's someone going to Josh, giving him a piece of paper and saying, you're being sued, you need to respond, show up in court. One interesting feature of this, there's a little bit of a difference by race. I forgot the confidence intervals, but I wanted to show you this one. This is the percentage of Jane or John Doe listed as the recipient of secondary service. Why is this important? It would be very hard for the courts to audit this, because someone, if the plaintiff said, well, we gave it to Jane or John Doe, Josh says, I didn't receive it. There's no one to ask if if it was actually delivered. And it's a little higher in defendants with limited English proficiency being higher in their zip code. I just want to point out two things in the judgment. One, for students who've had Policy Lab, yes, I used a pie chart. I will explain why pie charts are evil later, but it seemed like the one place it was probably good. But the main thing is that about 87% of these judgments are the amount owed on the debt, but that means about 13% are added on by going through the court system. And the average cost of judgment goes way down when people appear, and it may go down when they have an attorney. And the same thing, most of that is driven by the amount owed on the original debt. So what does all this mean? Josh, I need 1 extra minute, please.
Eric, you're good till, let's go 4:45. Let's
All right, good, I'm going
you're
for
good.
it.
You're awesome.
So here's what happens. Basically, vast majority of cases are default judgments. Courts, going to court raises the amount owed by people. Hiring an attorney increases the likelihood a case is dismissed. Hiring an attorney reduces the amount of a judgment, but very few people appear in court or hire an attorney. So what can we do? Well, remember, judges cannot be the lawyer for the defense. And a lot of the proposals that come up seem to take on that flavor. Why can't judges raise defense for people in these cases? So that's number one. Number two is there's a lot of proposals to try to find what's called sort of civil Gideon, find lawyers for low-income defendants. The problem is it's not going to pass the cost-benefit test. Lawyers, the reduction is about $300 in these cases, so it's going to be hard. Getting people legal assistance, I think, is a really a promising avenue. Simply sending them a text message and letting them know when they're being sued has sort of worked in other jurisdictions. But the problem is you got to make that sort of useful. My favorite one on this is maybe using some AI on this. It turns out where there's a checklist, artificial intelligence works very well. But what you would need to be able to do is flag the system where you actually, the AI can't help you and you need to sort of go to a lawyer or someone else. And right now, under unlicensed practice of law statutes in California, that would be very problematic. And I will say, limited training or paraprofessional programs have been used very effectively in other jurisdictions. Again, a problem for our unlicensed practice of law statutes in California. But if you would like to ask me in the question and answer session about how well my time serving on a committee, looking at the unlicensed practice of law goes, I can talk all day about that. What other options? I'll just say we could go with a full administrative system, but look, I think the LA courts have gone about as far as you can with that, and there's still a safeguard of hiring a lawyer. So I kind of like the LA court system better. We could change more on the time-barred debt statute, but again, that seems to require legal assistance. I do think it's probably worth thinking about some sort of legislation regulating process servers. I can go into that if anyone's interested. My favorite as an economist idea would be congestion pricing, which is basically having people pay for sort of the cost, the impact of filing. The only problem is right now you would transfer those fees to the defendant if it was a default judgment. And so that would really defeat the purpose. So having my favorite version of a carbon tax on really high volume filers is just simply not going to work in this one. And with that, I will stop sharing and take questions. Josh, I made it with 3 minutes to spare.
That was so good. Thank you so much, Professor Helland. And once more, Judges Heiberger and Kuhl, thank you so much for being here and weighing in. It's a real pleasure. At this time, everyone, I'm more than happy to facilitate a little bit of a Q&A. We have a couple of options here. If you would like to throw your question in the chat, you're more than welcome to. If you'd like to message me privately and you feel more comfortable with that, please do. Those are probably the two best ways to do it. And I want to point out that with already so many questions already have come in, I'm going to do my best to answer, to pose each individual's first question. And in some miraculous situation where we feel like 50 questions in 18 minutes. I'll circle back. So Eric, the first question that came in had to do with sort of those heat maps you were talking about in terms of being able to match people's ethnicity and last name to sort of get some of that background. We wanted to know what percentage of scenarios have geography predicting a different ethnicity than the last name, as if to say there's a disconnect between the two.
This is a great question. So I'm going to go on a very deep dive on the Consumer Financial Protection Bureau's method for sort of assigning people. So this depends heavily if it's an Asian or Hispanic surname, zip code matters relatively little. So if your name is Alvarez or something like that, it assigns a pretty high probability that you're Hispanic. If it's an Asian surname, same. Where the geography matters a lot is in differences between blacks and whites. And that one, the name similarity is pretty high. And so what the Consumer Financial Protection Bureau has done is it basically assigns, it's called a Bayesian updating system. It takes the initial probability based on your name and it updates it based on your geographic location. And then basically what it does is say which one of these has the highest probability based on the update, right? And so one way to think about this is we would take Eric Helland's census block, his census tract, and his zip code, and we would see how much those altered the 4 bins that he would sort of be placed in. The way we did this for the graphic analysis was we took the highest probability race, and then we basically assigned you sort of that race. The results actually work, just the graphs are messier if you do it by probabilities. There's a couple ones that we're just missing because it didn't work. For example, Native Americans, we just could not, we couldn't sort of pick out Native American names and sort of locations sort of in LA. So in the end, and then we had a few people that we had sort of trouble classifying. Basically, someone else has to, in the census, have your last name and spelling of your last name for this system to work. So we had a few unique names that we sort of had to throw out. Does that answer the question?
Yeah, that's great.
Thank you, Andrew.
Going to a different question, which actually came in over email, which is great. The question is, what percentage of the time is the judgment successful in the collection of debt? So assuming there's that's the judgment. If the percentage is high, why didn't the defendant work out the payment with the plaintiff since the defendant did not show up in court? And wouldn't it have saved additional expenses by the defendant?
Yeah, so this is the bad joke, but the $1,600 question of debt collection cases is, so I think one answer is people don't respond, right? That people, usually they go with the lowest cost method first when you sort of talk to collection companies. So the collection company calls, there's limitations under federal and state law on sort of when you can call and how frequently you can contact people and so on. And then at some point, they sort of, on cases that are valuable enough to sort of justify filing, they sort of go into court. I think the big question is this where because it's the process you have to take in order to be able to garnish wages or seize assets in a bank account or something like that. You can't do that without sort of the court order. And so I think what's going on is we're measuring the sort of the tail of these where the person hasn't worked out an agreement. The collector has decided this is sort of worth pursuing for sort of some reason. They've filed those, and the sort of end result is if the person does come forward, they'll sort of negotiate some sort of settlement and sort of drop the case, or simply decide it's too costly to sort of pursue the case. A fair number of these seem to be dismissed just unilaterally by the plaintiff. And then if that's not the case, then they sort of go and sort of look for assets. So I think the long and the short of this is that we're dealing with the kind of the breakdown of negotiated settlements. We're dealing with the small number of these. A huge proportion of credit cards are in default. Just a very, very large percentage of people in any given month are behind on their credit card bills. usually by a couple of months, at least according to the Consumer Financial Protection Bureau. And again, in the vast majority of these, people work out some sort of agreement and sort of get that resolved. And I think these are the cases where that sort of has broken down.
Awesome. Thanks, Professor. The next question was one that I was actually very curious about myself, which is what is the national average for the statute of limitations for collection of debt? And if it's unknown on sort of a national level, could you talk about what it's like in LA County or California?
So this is a great question. And I'm going to answer this in two parts. The first part is I don't know, but I think it's not very long. That is, I think it's sort of 4 years or something like that, sort of across courts. I want to make one quick point. The word time bar debt, and Judge Kuhl and Judge Heiberger, thank you for sort of clarifying this, because this threw us for a loop. We were like, well, how is time bar debt different from statute of limitations? It's not. So the statute of limitations applies to the specific state court's willingness to sort of hear a case beyond a certain age. And so it varies by court. I don't know why the number 4 years nationally is sort of stuck in my head, but I have literally no citation to sort of back that up. But that varies a lot by courts. What courts are doing there is a version of sort of self-protection, which says at a certain point, it's just too hard for the court to sort of adjudicate this. They don't know sort of who owes this. And this is the stuff of TV dramas, right? Is, you know, what's the statute of limitations on a crime or sort of something like, there's no statute of limitations on murder. All of us who went to the LA Law School of Law know this. And the idea, I think, is that these are things the court puts in place to protect itself from having to sort of adjudicate things that are very, very difficult for them to have the evidence to sort of do so. In practice, what that means is that the debt collector loses the only avenue they have if negotiations break down. I think the thing we shouldn't, as a policy matter, we shouldn't look at time bar debt as a, for want of a better word, the debt is just canceled. It's not bankruptcy. So if Eric doesn't pay his credit card bills and they're not able to sort of track him down within the sort of statute of limitations, he still owes that money. It still affects his credit rating. It will still be sort of difficult for him to sort of borrow money. It isn't as if it's bankruptcy and then there's a clean slate after a certain period of time. So I do think it's important that, I think this gets lost in the sort of discussion of sort of debt collection, is moving time bar debt takes away the sort of the enforcement mechanism of the courts, but it doesn't necessarily leave the person sort of without that obligation to pay. They would still have that on their credit rating or something like that. That's not a particularly satisfactory answer. I wish I sort of could tell you what it was around the country. It does seem to have a high degree of variability, to sort of depending on the courts as to sort of when they'll sort of hit this. I suppose, Judge Heiberger, Judge Kuhl, do you actually know what the kind of, not to put you on the spot, neither of you are actually in collection courts, but I wonder if you know the answer to this.
I don't to that, but I was going to make one comment. So the hypothetical debt could be a 30-year mortgage.
Yeah.
Perform on your 30-year mortgage for 11 years because you got a decent job, you haven't had medical bills, and you haven't been divorced. So the debt's 11 years old and you paid all your monthly payments, no reason to sue. You can't look at the date of the debt to figure out what is the age of the debt in terms of how long you have to sue. So if after 11 years of paying your mortgage, you just decide not to, or more likely you've had a medical problem or divorce or lost a job and you stop paying, that's when the time starts clicking. So it can be very hard. You can't look on the face of the debt. Now, if it's consumer debt, like a credit card, presumably it's the first month you shorted the bank the minimum payment. And that presumably, they're not going to sue you immediately. They're going to do the lesser techniques. But at some point, they'll presumably know to sue you in time. I tried a case earlier this year involving what happened in a workplace. It wasn't a debt collection case, but the facts were 12 and 13 years old. And I can assure you, it's a very messy and awkward process to try to have any credible evidence of what happened 12 or 13 years ago.
And I would add to this, one other thing that comes up in these cases is if you do respond, so there's a collection out, it's 3 years old, you respond to the collector, it actually resets the statute of limitations. And I think that's an important point, that often gets missed in these reform discussions is that, again, because it's there to protect the court, the evidence is now fresh, right? Eric has said, yes, I owe this money, and started trying to pay again. And so it resets. And so I think this is it's used a lot in the sort of reform efforts, but it's very, for want of a better word, clunky in terms of how this gets handled.
Professor, a very different question that came in. I was wondering if you'd talk about what's next with the policy lab and what is going on currently with the CMCers that you're working with.
So I'd love to. So right now, Professor Courser and I have been sort of alternating what sort of project. So our next project is probably going to be something on elections. We did a project earlier looking at kind of the impact of pandemic era election reforms in voting and what the sort of impact on turnout was. And so we've got some evidence that we're sort of working with the Bipartisan Policy Center on that. And then we run a program called Summer Associates, where we sort of usually, Professor Courser and I each take a team. And so I'm still working on kind of what the sort of the next project, for the summer will be. But at least in the spring, the plan is to probably go back and do something on an update on elections. The elections research is really fascinating because we got a number of states instituted universal vote by mail prior to the pandemic. And so what we were able to do was get voting records for everyone in California, Utah, and Montana, all of which had phased rollouts. And surprise, surprise, it turns out voting by mail actually increases turnout. But it doesn't increase turnout, I think, in the way that the sort of usual political discussion goes. It increases turnout among voters who are regular voters. And it led me to what I think of as the soccer practice theory of voting, which is I vote in every election, but if it just turns out like, you know, it's a really bad Tuesday and I'm an in-person voter and the kid's soccer game runs long and I don't make it to the polling place, I just occasionally miss an election. And that seems to be what's vote by mail is reducing that. And it's also particularly true for sort of older people. They're sort of much more likely to vote. So I think our research there suggests not a big political valence in sort of who uses these, Montana and Utah being very red states, California being a very blue state, but a big valence in sort of making it easier for sort of regular voters. So we've been doing some sort of work on that. I have a couple presentations coming up with the Bipartisan Policy Center, but that was our big project. So I think in the spring, we're going to go back to some sort of election study. And then probably in the fall, we'll sort of return to sort of a civil justice project. So we're kind of alternating sort of between those two in terms of what we're sort of working on.
Awesome. Eric, thank you so much. We are in the fantastic situation right now where a lot of the questions that came in have already been addressed, which is awesome. If anyone has any additional questions, whether it be after the call that they want to field and they want me to forward over to Professor Helland, please feel free to email me and I can always make their way through. Professor, thank you so much for this talk once again. Judge Heiberger, Judge Kuhl, thank you for being here. I encourage everyone at this point, if you would like to unmute yourself just to say thank you, give a little bit of round of applause. And one last thing, I will circle back with all of our speakers today to see how they feel about sharing this information, and I'll follow up as necessary. I've got everyone information who requested it. And on that note, thank you all so much.
Thank you.